what's the process look like after that ruling is issued, and how do you find out about it, and how important is the wording? You said she's probably writing something about the disparate between the owners and the players, the way that they're applying the personal conduct penalty. How important is that wording? Because that's what she's finding as fact, correct?
That factual determination and legal determination can't be disturbed on appeal because that's a factual finding. Under the new CBA, Roger Goodell's ability to change the ruling below is limited to modifying the amount of discipline, not the entitlement to discipline or the validity of any defenses. So if Judge Robinson finds, and by the way, the word disparate discipline, that's a little bit of a mouthful. I think it might be a little bit more user-friendly to refer to it as selective enforcement, in that the league will enforce the personal conduct policy against players and not apply it to the owners and league executives. So that's a selective application of the personal conduct policy. So maybe we'll use that going forward. That aspect of her decision, I believe, based upon the way the CBA is written, cannot be disturbed on appeal by Roger Goodell. But conversely, if she rules against Deshaun Watson and finds that the other cases involving Dan Snyder, Jerry Jones, Robert Kraft, and Jimmy Haslam are irrelevant, Watson and the NFLPA have no recourse in seeking review of her determination that it doesn't apply, because Goodell's authority as an appellate judge is limited to modifying the discipline, not reviewing any of the underlying findings of fact or conclusions of law. And then when you get into federal court, the court does not reweigh the evidence. The federal court's only inquiry, and this is not good for Deshaun Watson or anyone challenging a labor arbitration award, the court's review is limited solely to determining whether the arbitrator, in this case Roger Goodell, acted within the scope of his authority as outlined in the collective bargaining agreement. And here, the CBA expressly grants Roger Goodell the authority to act as the appellate judge to modify the discipline, either upwards or downwards, that has been meted out or rendered by Judge Sue Robinson. So based on the language in Deflategate, and that's the sort of the scope of the authority language of the Second Circuit's opinion, as long as Goodell was acting within his authority, even if he got it wrong, even if the court would have made a different decision, there's no basis to overturn Roger Goodell's additional discipline so long he was acting under his authority granted to him by the players under the CBA. And I don't know how you get around that. See, the Deflategate decision from 2016 made it infinitely more difficult for players to challenge NFL disciplinary determinations. It really narrowed significantly the basis under which an NFL disciplinary decision can be reviewed by a federal court. It basically has to be acting outside the scope of the authority or imposing the arbitrator's own brand of industrial justice. An example of that would be if Roger Goodell took a determination that Deshaun Watson was suspended for 1 game or 2 games and instead raised it to an indefinite suspension of 1 year or more, which is what the NFL asked for initially before Sue Robinson. So if Roger Goodell reinstates or uses the same baseline that the league asked for back when it was arguing before Judge Robinson, a federal court may properly view that as the NFL arbitrator imposing its own brand of industrial justice. And that would be the narrow sliver under which Deshaun Watson would be able to successfully challenge any decision by NFL Commissioner Roger Goodell. Likewise, if Roger Goodell disagrees with any of the factual findings made by Judge Robinson and decides that Judge Robinson got it wrong on the issue of disparate discipline, or she should have found that Deshaun Watson committed a violation of the personal conduct policy, if he tries to disturb those findings on appeal, then the commissioner would inarguably be acting outside the scope of his authority, and then Deshaun Watson would be able to get a favorable federal court ruling even under the Deflategate precedent.